Good evening. This is Dale Lamb with Gardner-Webb University. This is Mels 603. This is our 13th weekly session. It's Thursday, December the 8th, 2016. Hope you've all had a good week and are getting ready for the holiday season. I'll dive right in tonight. Week 13 was about sexual harassment. It's become such a hot topic in schools that I decided to dedicate a whole session to that and some other things that are antecedent to that. And so I had a discussion board. Many of you answered this week. Examine a school district policy on harassment, citing policy, explain how you would respond to a complaint. I had a case study for you to view. By this time, you should have about all of your work is due this week in Blackboard and TaskStream. If you've got work that still hasn't been peer reviewed, send it to me. I'll peer review it and get it quickly. Remember, if work has already been submitted to TaskStream, you don't have to worry about getting it peer reviewed. Some of you had some work to do that. If you've got work that's outstanding that needs to be evaluated, send me an email about how much work you've got. If it's been in a week or more and it hadn't been evaluated, you hadn't got a score back, send me an email. So again, if you submitted work for evaluation and it has not been evaluated, it's been a week or more, email me that so I can get after the responsible person. If you have work that needs to be peer reviewed before you can put it in TaskStream and it has not been, send it to me and I'll peer review it for you. If you have work that's already in TaskStream, submitted for evaluation, it doesn't, and it hadn't been peer reviewed, don't worry about that. It doesn't need to be if it's already been submitted in TaskStream. Okay, so that you should be finishing up pretty quickly here with all the things. Please remember, if you do any final evidence narrative submissions, that there's a button where you go to upload that work that says complete form. Make sure that you put your summary and descriptors. That's only for the final submission for each of the 6 evidence artifacts. It is not required for a component. So make sure that you do that. All right. So next week we will finish up and I will go over interviewing with you. I've already started that, but I will hit that again for you. All right. So all right. I'm going to start out tonight on sexual harassment from the North Carolina Discipline Data Reporting Procedures Manual. And let's look at sexual harassment first tonight, not from the act itself, but from an administrative perspective. See, one of the things that we talk about, you got to follow federal law, state law, local board policy, those kinds of best practices, teacher input. We have a, as you learn doing the OMA this semester, you have a priority or a rationale as to what you have to follow in scheduling and operating or managing your school. This was about management this semester. And one of the things that I'm concerned about is that you know where the policy is and you know what the policy says, but I'm not sure that students understand the legal steps that they're supposed to take in dealing with certain situations. So let's look and see. Now, this manual says that there are certain acts of misbehavior on a school campus that have to be reported, and harassment, sexual harassment, has to be reported to the state because the state reports it to the Office of Civil Rights. Okay, you put it into Power School and it's logged in as sexual harassment. But my issue tonight is how do you deal with that? When a student comes to you and says, the following happened to me, one of the things that I'm afraid of is that folks have this notion that they must begin their process with an investigation. If a student comes to you and says, a male teacher has said X, Y, and Z to me, or if a student has said X, Y, and Z to me, um, where do you start? Well, again, they said X, Y, and Z. So the first thing that you would do is you'd have that student write a statement. Well, that's part of due process. They would write that statement. Um, the second thing that you would do is you would make a call to the appropriate person at your central office and say, I've got a charge of sexual harassment here that I'm going to begin an investigation, and it involves a staff member. What would you like me to do in terms of employee or human resources or those things, and let them guide you if an employee is involved. If a student is involved, you might want to call your disciplinary data coordinator, whoever that is for your district, and say, I've got this situation, I'm going to launch an investigation. What would you have me do in order to preserve evidence, or what things do you need for, to make a case or not make a case or make a determination? So the first thing that I would do after having the student write me a statement is I would contact the appropriate person at the central office and say, I've got a charge on a staff member, tell me what to do next. Or I've got a charge on a student, what data or do you want me to collect, or what do you want me to do next? And that would be my first response as a school administrator, because sexual harassment has become a very, very, very serious business. It can ruin careers, it can ruin lives of children, on both sides, victim and perpetrator. And so you want to make sure that your central office, the appropriate person, and they may be the same person, but probably not. Usually, if a student's involved, you have a disciplinary data coordinator for your district, usually a director or program coordinator or assistant superintendent who eventually handles all that stuff if it goes to a due process hearing. On the other hand, if a staff member has been involved, HR wants to know that immediately, so that they can send somebody out. They may send somebody out to help you or to guide you through the process. But don't take that one on alone. Even if it's just two kids, don't take that one on alone. We've covered tort liability this year, and if something goes wrong and evidence is mishandled, or the investigation is not conducted to the parent's satisfaction, there's going to be a lawsuit. That's become standard practice in the business today. So you need to make sure that you get the right people involved with you that can do the right things. Now, instead of that female student coming and saying, the coach said something inappropriate to me, or the student said something appropriate to me, they come to you and say, the student has done something, the coach or the student has physically done something to me inappropriately. We've just gone from sexual harassment to one of the acts of crime and violence. So let's look at those right quick. Now, these definitions are very graphic. I apologize before I get to them, but for the graphic language that they use. But if what they tell you falls into one of these categories, it is no longer an act of harassment. It is now jumped over into an act of crime or violence. And that's going to take a whole nother turn. So what's going to happen if they tell you that one of these things has happened? Let me get down here. Okay. Rape, intercourse by force or against the will, or if the person assaulted is mentally disabled, mentally incapacitated, physically helpless, or the person performing the act knows or reason knows the other person is mentally disabled. So, if this female student comes and says, so-and-so had sex with me against my will, or so-and-so had sex with me, if they're more than 4 years older, if it's one of your staff members, now we're looking at rape. we don't, our first call is not to the central office if an act of crime or violence has occurred. And this is very important because you don't want to be on the witness stand and the attorney for the parent who is suing you asks you the question, why didn't you call the police first? Were you engaging in a cover up of some sort? Now they won't let you explain on the witness stand. Now let me be clear here. It's not like you would think it would be. It's not Judge Judy where you get to go in and plead your case in civil court. This is criminal court now. Or if it's a civil case against you, when they ask you these questions, they're yes or no. Did you call the police first? Well, I was no. Did you call the police first? Well, no. And then they'll spin and twist that into something where you were trying to engage in some sort of conspiracy to cover this thing up. So if a crime, an act of crime or violence has occurred, and rape being first among that, your first call is to the police. If you have an SRO on your school resource officer on your campus, your first maneuver after having the student write a statement for you, and I might even go and get the police officer to be there when the statement is given. I think if I had a police officer on campus, I would go get the police officer first and have the police officer come and take the statement to the police because they have informed you that an act of crime or violence has occurred. I believe I would let the police officer take the statement to preserve the chain of evidence. And you could have the student be writing a statement while you're going to get the police officer, but I would have the police officer in fairly quickly. And what you'd like is for the police officer to take the report if it's an act of crime or violence. You can have them write a brief statement for you, for your records, the time and date that they told you X, Y, and Z, and they sign it and you sign it. But then you'd like for them to give their detailed statement to the police officer and let them take down the statement themselves. Now, inside of this rape, again, if it's 4 years older, here comes Luke. Luke, are you there? I see you now. You there, Luke? Luke, are you there?
I'm there.
All right, Luke. Thank you for being with me. So,
sure.
If a student reports sexual harassment to you, you have them write you a statement and you call the central office to have them guide your investigation. You call the Human Resources Department if it's an adult that works at the building that they claim has sexually harassed them. You call your disciplinary data coordinator for the district if it's a student. Now, if they come and report that act of crime and violence has happened to them, you have them write a brief statement, and while they're doing that, you make sure you call the police or you get your school resource officer. You would like in an act of crime and violence for your police officer to take the statement directly from the student to preserve the chain of evidence. So if they come in and said somebody had intercourse with me against my will, you would obviously call the police immediately, whether it's a staff member they're accusing or whether it's another student they're accusing. Now, embedded in this is a situation that I know a lot about. This first one here. During my days in the central office, we had a high school where a female student came who was 16 years old. And in the state of North Carolina, 16 is the age of consent, by the way. And she was 16 years old when she came and said that she had had sex with another student and that she felt like that it was against her will. Well, the school staff, number one, didn't call them the resource officer, which is a no-no. And they kind of had her make a statement and put it on the back burner, and it didn't get investigated for a while and didn't get called in. And the reason why is, when questioned, the assistant principal who was supposed to be handling it said, well, she's 16 years old. It's the age of consent, can't be rape. She said if she wasn't forced, she came and reported she'd had sex with him. But what they didn't remember, or what they failed to recognize or failed to acknowledges is even though that she was 16 years old, she was in a self-contained exceptional children's class. If the student is in a self-contained exceptional children's class, they are mentally disabled and they are not capable of consent. Let me say that again. If you have a student on your campus, regardless of their age, if they're 16, 17, 18, 19, it doesn't matter. If they are mentally disabled, mentally incapacitated, physically helpless, and the person performing the act knows that, then they do not have the ability to consent, and that is a crime. And that's what ended up costing that principal his job, and the AP and a couple more people, is that they didn't bother to call the police and get started. Well, she's 16. She said that he didn't force her, but she can't consent. She's not doesn't have the mental capacity. She's mentally disabled. So again, if an act of crime and violence occurred, it's no longer sexual harassment. It's either rape, if there's any contact, sexual assault, not involving rape or sexual offense. A person is guilty of sexual battery if he or she, for the purpose of engaging in sexual contact with another person by force against the will of the person. And sexual contact is defined by state law as touching the sexual organs, anus, breast, groin, buttocks, or any person with their own sexual organ, anus, breast, groin, or buttocks. And so what we're talking about here is if a boy rubs up against a girl or rubs her behind or rubs her somewhere, that is a crime. That is a sexual assault. That is not sexual harassment. See this is the one that causes the most consternation. When a girl comes in and says, "Boy, touch my behind," school officials mistakenly treat that as sexual harassment and launch into an investigation of their own. That is not sexual harassment. That's a sexual assault if touching is involved. Same thing as a rape. You have them write a statement while you're getting the police, and then your second call can be to the central office, to the appropriate person. If the person accused is a staff member, the girl said that the coach rubbed my behind, then you call HR, let them guide. But you tell them, first thing you tell them, I have informed the school resource officer, or I have called the police, the resource officer from the local school if it's an elementary school. If it's a student that rubbed the other student, your call then would be to the disciplinary data coordinator and say, I have the police working on this. What would you have me to do in terms of gathering witness statements or process, or what do I need to make sure that I do, that I don't break the chain of evidence or destroy evidence or contaminate the evidence against this person? So the difference in where you go with a sexual harassment and a sexual assault is that first step of calling the police. Generally, what happens after you conduct your investigation on a sexual assault or sexual harassment, you may involve the police later on once you have evidence of it. But school personnel are not qualified to do investigation of sexual crimes. These are acts of crime and violence. So if the girl says, "I've been touched," that puts it in the category of a sexual crime, police, and then one of the agencies at the central office that would be appropriate to handle that one. So, I mean, this one is pretty simple. If the boy rubs the girl's behind, we need to get the police involved. Now, first degree sexual offense, second degree sexual offense. Again, in the sex act with a victim under 13, 12 years old, and the other one is 4 years older, force or will, deadly force, influence, injury. If there's a second person there helping them to assault this person, if it's over 18 and the victim is 13 or younger, and again, the mentally incapacitated, mentally disabled statute applies on this one as well. Um, the person may be 16, but they cannot consent to this. So statutory rape or sexual offense whose person who's 13, 14, and 15, if they're more than 4 years older, or if they can't consent, it's statutory rape. Again, it's a sex crime. Police, proper authority at the central office to guide you, whether it was an adult that works there that's been accused or whether it's a student. And then taking indecent liberties with a minor, obviously that's going to be staff, but again, your first call is to the police. No, the consent clauses in this one too, in terms of mentally disabled. So first call police, second call on this one would be to HR. So those are the sex crimes: taking indecent liberties with a minor, sexual offense, which has 1, 2, 3, 4 categories, including statutory rape, sexual assault, which is touching, and then rape. Those are your sexual crimes. Any of those are not sexual harassment. If any of those are reported to you, you have a student write a statement immediately while you call the police, or you get the SRO, or you get the police. And then your next call, this is important, your next call is in to the appropriate agency, whether it be human resources, if it's an adult who's been accused, or your disciplinary data coordinator, if a student has been accused. You want to make sure that you do this the right way. Again, you do not want to be on the witness stand under oath, being cross-examined, trying to, not being given the opportunity to explain why you didn't call the police first. So that's the differentiation, is the process that you take. So it's very important that you listen carefully to what the student tells you. And if the students came to me and said, Coach so-and-so or the boy down the hall said this to me, the first thing that I would ask them is, did they make physical contact with you in any way? And if they said no, I'd say, all right, start your statement, write me a statement as to what happened while I make this call. And I'd step out and make my call. Or I'd move them to another room adjacent, like a conference room, while I made my call. And I would call HR if she's accusing an adult of saying something inappropriate, or I would call the discipline data coordinator if you were accusing somebody, another student, of saying something inappropriate. As soon as she said, yeah, he also did this to me, in terms of he touched me, he did something physical to me, all of a sudden, again, while I'm having her write her statement, my call now is not to the central office, but it's to the police. I know I'm overstressing this and I'm grinding this point in the ground, but this is about your job. This is the worst mistake that you can make when you have one of these cases, is calling the wrong person first. Because that will be construed the wrong way, I'm afraid. So make sure. All right. Make
So
sure.
anytime there's physical contact, it's police first, right?
That's exactly right. Anytime there's any kind, anytime that there's physical contact, I'd get the police involved and let them take the statement from the student. I'd have the student write me, and I'd tell them, write me a brief statement, but then they would give a more detailed statement to the police. And people say, well, gosh, that's so time consuming. And that's one of the things that, one of the discussion boards I had you do this semester, that, when you interviewed the assistant principal and asked him what was they surprised about 90% of every class that I've ever taught in 603, and I teach one every semester, the response comes back, how long it takes to process discipline incidents, how long that it takes to make sure that due process is upheld. Yes, it does. It takes a while. But this is not the one to scrimp on time. This is not the one to put on the back burner and tell the girl to come back tomorrow. Or this is not the one that I'll look into it kind of thing. This, when one of these comes to your office, you better handle it now, and you better handle it the right way, because this is about your job. It's not just about your job, as we learned this semester. tort liability extends to you personally, financially. There was a case in Union County that was in the 1980s, and I think it was probably the court case was decided, I want to say, in either 90 or 91. And as a result of that, every principal in the State Department had us trained by Richard Schwartz and Associates, a law firm out of Raleigh. Now, I'm sure that they didn't send out everybody from Raleigh, but they contracted the work out with other lawyers across the state, and every principal in the state had to sit down and learn about tort liability and learn about sexual misconduct or sexual assault, sex crimes on campus, and what would happen to you if that happened on your campus and you didn't follow the right term. And that's been 27 years ago. The state felt it was important enough at that time that DPI paid for that. For us, all sitting principals in North Carolina at that time were trained. You got to call the police. The police does the investigation. You do not do the investigation. You are not qualified. You make sure they do it. It has to be reported. If you don't, you will be legally found liable. We're telling you this from the state, so we can't be. Now, the state, look at it from their point of view. They weren't doing this because they liked us or thought it was the right thing to do. What the state was doing was passing that tort liability on down to the school districts and to the principals. And they were telling them, now, if you get sued, we're not going to be part of it because we spent money to train every one of you and tell you not to do this. They weren't doing it for the good of the group. They were trying to abrogate their legal responsibility. Somebody sues, who's got the most money? Me and Luke, the school district, or the state? Well, it starts at the state. They got the most money, and then the school district, and then the individual person. And what they were trying to, and what the state and the local school district that I worked in at that time was trying to impress upon us, we're going to get out of the way and let the bus run over you. We are not going to accept that legal liability, because the case that was decided in Union County, the state had to pay, first time ever. The state had to pay, the local district had to pay, and the principal himself, who ignored that this child was being sexually abused by a staff member, that principal had to pay. All three had to pay. That was a landmark case in North Carolina, the first time ever that a victim could recover damages against the state, the school district, and the actual leader of the school. And it was such a watershed event that the state said, we don't want to have to pay out anymore. And the local district said, we don't want to have to pay out either. How can we do this? And so they had us all trained, which shifted the blame to us. And so nobody at the central office is going to stand up and say, well, Dale just made a mistake. Luke's a good guy. He didn't mean to do that. I'm sure that he just forgot the procedure or the policy. That you're going to be dead under the bus. And if you don't believe the police won't throw you under the bus, the situation that I'm talking about that happened in one of our high schools, where the EC, self-contained young lady, came in and reported that she'd had sex with another student, and it wasn't investigated, wasn't reported to the police, and she was mentally incapacitated. She was mentally handicapped and was not able to consent, even though she was 16. Her parent went to the local police department. It wasn't in the city of Charlotte. It was in one of the outlying small towns, suburbs of Charlotte, and their police department, that school lies within their jurisdiction. I never will forget. They did an on-camera interview with the police chief in that small police department in that small town, and the first thing they did was they threw the school and the school administration right under the bus, and they were even driving the bus and backed up and ran over them a second time. Said, we certainly believe something happened here that was criminal in nature, but because we didn't get it and because the school tried to conduct an investigation, we have no way of knowing if any of the evidence has been tainted, and we certainly feel like that this young lady's rights have been violated. But it's the school's fault, and there's not a thing that we can do about it. I mean, it was brutal. It was brutal. And after that happens, as my mother would say, your hide wouldn't hold shucks after that. After that happens to you, you take such a whipping on such a thing as that. There's no way to recover. You're done. Your career is over. Um, you're going to be doing something else to make a living for the rest of your life. It won't be in the school business. Once the police throw you under the bus that hard, you've lost the public trust. You know, no group of parents is going to stand for you to be principal at their child's school. They don't feel like that their child is going to be safe under your watch. You know, the only good thing that came out of, I mean, it wasn't a good thing, but at least the principal was old enough to retire, and he was a well-respected principal, and had, and this was just a bad thing, but it was a bad thing for the child too. The child wasn't old enough and didn't have the capacity to consent, but you can't recover from this one, folks. Just let me tell you, you will not recover from this. So listen very carefully when students come in. I know you're busy, especially you assistant principals, and you got to, if you're at certain schools, you got to line out the door every morning to handle for discipline. You're calling kids in. You're dealing with what happened on the bus that morning and on the bus the day before. You're dealing with what happened at breakfast and what happened in the commons before school started, especially if you're in secondary school. I know you're busy, but when a student comes in and says, "This happened to me," sexual harassment happened to me, you know what to do. Have a right statement. You call HR if she's claiming that it was an adult employee. You call your disciplinary data coordinator if she's claiming that it was a student. If she said, "I was touched, I was raped, I was sex against my will," if something physical happened to that student, start the statement, get the school resource officer, get the one from the neighboring school. If you don't have one stationed, if you're an elementary and don't have one stationed at your school, you get that person immediately. And if they can't come immediately, they're at training day or whatever, then you call their supervisor and you get somebody there immediately.
Mm-hmm.
You with all deliberate haste, you get a policeman there to take that statement. Now, after that, next steps. More than likely, the police are not going to involve you in their investigation, other than being a witness to that the girl came in. That's why you have her write the statement, so you have that with you. But more than likely, the police are not going to involve you in an investigation of a sex crime. They have a special person. And I'll use her name. I know that because Luke and I are talking tonight, in CMS, Angie Cathcart comes out and does sexual investigations. She's a detective in the police department for Charlotte-Mecklenburg, and she has been trained, and she is known statewide for her ability, and that's what she does. I think Detective, was it Kenny Lynch? I think Kenny also does some of those investigations. It's according to the gender of the person who has been assaulted. And so those are the two people in Charlotte-Mecklenburg that I know of that have been trained specifically that will come out and start the investigation. That's what they do. They do other things in between, but that's exactly what they do. And they're good at it, and they're very professional. And they won't just run over you as a principal. I mean, they come in and they have their job to do. You don't want to be in law enforcement. They don't want to be in school administration, and they will be respectful, and everything will go. And that's the way it'll be. I don't know of anywhere that I've ever worked or that I've had interns that I've taught that would be that you would regret having done that. But you need to lessen your legal exposure to tort liability where you would have to pay money. All right. So that's a long-winded explanation, but make sure you follow those rules. Now, the second thing tonight that I want to go over is sexual harassment. Once you've determined that no physical contact has happened, you have called the appropriate person and they have given you guidance. Hopefully the guidance will be in terms of what kind of questions you need to ask that student. See if there's any witness. Can they provide you any names of any witnesses? Specifically what they said. So we've already covered persistently dangerous crimes and those kinds of things. Gang awareness, that stuff. Sexual harassment, identification, and prevention. One of the things that you're going to be asked about, if you have a lot of cases of sexual harassment, one of the things that you're going to be asked about is what are you doing to prevent this? If you have more than 3 or 4 fairly early in the school year, you're going to be asked by the folks in the central office, what are you doing to prevent this? So the first part is identification. Sexual harassment of students is illegal. Title IX protects students from harassment connected to any academic, educational, extracurricular, athletic, or other programs, regardless of the location. So this notion, well, they were in an away ball game, not my problem. Yes, it is. If they were both students at your school and they were at a school activity, regardless of location, it is your problem. Protects both male and female from harassment by any school employee, another student, or any non-employee third party that happens to be like another parent or a vendor on your campus. And that's one of the things you need to be really careful about, especially in secondary school, is vendors being on your campus. Because sometimes I've told you the story where I had an insurance vendor on my campus when I was an elementary principal. And I had a teacher complain that she didn't feel safe at work, that she felt sexually harassed because she heard the vendor ask another teacher out on a date. I won't debate whether or not that was, whether she should have felt that way, but she said she did. So, that falls under the, Title IX scope. He was a non-employee third party, but he was a vendor on campus. That he didn't work there didn't matter. That it happened after school didn't matter, and that the teacher he asked out said yes, and didn't matter. None of those things matter. No person in the U.S. shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or subject to discrimination under any education program or activity receiving federal financial assistance. Schools have the power to discipline students if they use obscene, profane language and gestures. So, when we talk about identification, we'll get to that. But when we talk about prevention, I've talked to you earlier this semester about antecedent behaviors. If we see a lot of hugging and kissing in the hallway, you're going to begin to see sexual infractions. If we see inappropriate display of affection, walking around all hugged up and kissing and doing all those kinds of things, you're going to begin to see sexual infractions. If you see a lot of shouting profanities and gestures in the hallway at class change, you're going to begin to see sexual harassment. Those are the antecedents of those things. So schools do have the power to discipline students if they use obscene, profane language or gestures. There's the court case cited in '86. Free speech is not always free. It's kind of like people in this country have this misguided notion about what free speech is. Free speech means is that you're free from retribution by your government. Now, that doesn't mean that your employer or that your school district can't take action against you. So people have this notion that free speech means is that you can't take any sanction against me for whatever I want to say out in public. That's not true. It means the government allows that, but it doesn't mean that your employer or your school district allows that. And so, I've seen people that complained that they were sanctioned at work, or their parents complained that kids were just voicing their opinion or whatever. Well, you have the right to do that, but that doesn't mean that there are consequences for doing that. And here's the law that defines that for us in public school, because those things are inconsistent with the fundamental values of public education. School districts should be held responsible for harassment by educators, and what this says under Title IX, and they are. And even if you're not the one who did it, again, you can be held responsible if you allow it to go on. That's why I said you have to take action, especially what you want to do is take action at the lower level stuff, the antecedent stuff, and then the bad stuff at the end. But again, the persons of authority that see it happening and don't say anything about it, you are held accountable for that, or responsible, and you can be sued and held tort liable and have to pay. And here is another one. Schools were assigned liability for peer-to-peer sexual harassment if the plaintiff sufficiently demonstrated that the administration's response showed deliberate indifference to actual knowledge of discrimination. You can't just ignore these things, especially well, it happened out in a common area. It wasn't directed at a single person, or it wasn't in a private physical encounter. It didn't get physical. Doesn't matter. Harassment is harassment, whether it took place in the commons or a classroom. You are to take action. And that's why, now this is why I said, if a student comes in and says they've been harassed by another student and it wasn't physical, you take their statement. The first call is to your disciplinary data coordinator, because this is what you need to know. You explain the situation to them, and they tell you what your response is supposed to be, or what legally required responses that the district wants you to put in place. Mm-hmm. The district has a policy. We have in every school district, we used to be in actual notebooks. We had a big thick notebook, a white notebook with blue pages in it, and that was board policy. But we also had a white notebook with yellow pages in it that was called administrative policy, that led you through what you're supposed to do when situations occurred to make sure you followed the law. The book was called administrative policy, and that's why I said that stuff's all online now. Sometimes it's hard to find. It's not at your fingertips, and if you don't deal with it every day, when somebody came in and said I've been sexually harassed, again, I'd have them start their statement, and I'd make the call. Even if it was student to student, I would make the call to the DDC, the discipline data coordinator, who's usually an assistant superintendent, and say, all right, tell me what I need to do, so that I have, to make sure that I have complied, I have demonstrated a deliberate response rather than a deliberate indifference to this form of discrimination. Sexual harassment is a form of discrimination. State statute Article 29C, school violence prevention on bullying and cyberbullying. Bullying or harassing behavior is any pattern of gestures, written, electronic, or verbal communications, any act, physical act, or any threatening communication. A physical act doesn't mean, a physical act is like shooting the bird or making a motion or doing something like that. A physical act is not physical contact. That moves it from sexual harassment to sexual assault. If it takes place on school property or any school-sponsored function, school bus, and that places a student employment in actual reasonable fear of harm to his or her person, damage to her property, creates a hostile environment. That's what I was telling you earlier. I had a teacher who complained that hearing one of her colleagues being asked out on the date created a hostile working environment. That's legitimate. It falls under that category. If that happens, the school has to take a deliberate action, not a deliberate indifference. And so, for the purpose of this section, hostile environment means the victim subjectively views the conduct as bullying or harassing behavior, and the conduct is objectively severe or pervasive enough that a reasonable person would agree that it is bullying or harassing behavior.
So what will school do about that?
We had to ban that fellow from coming on campus.
Wow.
Yeah. Exactly what we do. And so the insurance company had to send another representative to service our school. Yeah.
That seems extreme, though.
That's the law.
Yeah.
You know, I didn't fault him for asking the young lady out. He was a young man.
Mm-hmm.
What I faulted him for was, and I wasn't the one that made the decision. Again, it went back to the central office. I, called it in, did what I was supposed to do. The central office, working in a school as a vendor is a privilege, not a right. And you have to be on an approved vendors list to do that. And that's one of those things that, if you don't abide by the rules, you're off the list. And so they had to send somebody else to service our school in terms of our insurance agent with Horace Mann Insurance. It is severe, but that's the penalty. I didn't fault him for asking her out. I faulted him for asking her out in front of other people. I thought that was a poor choice. Even if it hadn't created a hostile environment, and you can debate whether it did or not. I don't think you ought to be asking folks out at their place of business in front of their coworkers. That is a little crass, I will have to admit. Bullying, harassing behavior include but not limited to reasonably perceived as being motivated by actual or perceived differentiating characteristics such as race, color, religion, ancestry, natural or gender, socioeconomic status, academic status, gender ID, physical appearance, sexual orientation, or disability. These, not limited to, but these are the common ones that students harass other students with. It looks like I've lost Luke. Maybe he'll be back in a minute.
I'm here.
You still there?
Yeah.
You dropped off my screen. Let me see if I can. There you are. And there's Julietta.
Yeah.
All right. So that's why she bumped you off for a second, but you're back now. All right. So,
hello.
So here are the actual things that students or adults harass others about. And of course, we've gotten into a lot about gender ID lately. That's become forefront in North Carolina because of HB2, gender ID and sexual orientation. But the law is very clear. You cannot discriminate against people because of those things, and you cannot harass them because of those things. No student or school employee shall be subjected to bullying or harassing behavior by school employees or students. That's pretty straightforward. No person shall engage in any act of reprisal or retaliation against a victim, witness, or a person with reliable information about an act of bullying or harassing behavior. And that's another reason why I said you need to call the appropriate person at the central office to guide you through. You want to make sure that they tell you, well, I want you to do this and that and the other, do it this way, do it that way, because you don't want to expose others to retribution. And they will generally guide you through that. They may have you, they may send somebody else to do it. Every district different, every situation is different, and every district is different. One of the things that a lot of districts do is they'll send somebody out to even do these kinds of investigations to try to take the burden and the chance of retribution off of the people who work at your building, or they do, they do this to students in secret so the other students won't know if they've written statements. A school employee who has witnessed or has reliable information that a student or school employee has been subject to any act of bullying shall report the incident to the appropriate school official. And then you will report it on up the line and take the statement, and then you will conduct the investigation as directed by the responsible person at the central office, who is your supervisor in this matter, whether it be human. Generally, HR will send somebody out to investigate an employee misconduct. That maybe in small districts that doesn't happen, but usually that does. A student or volunteer who has witnessed a reliable act should report the incident, or even a third. One of the biggest cases we ever had in Charlotte-Mecklenburg was actually reported by a vendor. A person out at the ball field working on the scoreboard reported, one of the bigger cases we ever had. So, but he knew that it was, one of the things that vendors do is vendors are trained, or they go through some training, and they're told what they're to do if they see something happen. Of course, I'm sure they're trained at their place of business. And this gentleman said, I saw this happen. And he came into the school office and he wrote a report. He said, I know I'm obligated to do this. We want to continue working for CMS. I saw this happen. I think he was spurred on by the fact that some other people saw it too. And he was afraid if he didn't come report, the word would get back that, the fellow working on the scoreboard saw this and he didn't say anything. And so he came and wrote a report, but they're required to too. 115C407, that's in the North Carolina General Statutes. Each local school administrative unit has had to adopt a policy prohibiting bullying or harassing behavior and had to put a bullying prevention program in place. And that bullying component should have a statement prohibiting bullying or harassing behavior, a definition of harassing behavior, and description of type behavior expected for each student in each form. That's why, just like in Charlotte-Mecklenburg, it's the Rights and Responsibilities Handbook. It says, here's your rights, but here is the responsible behavior, the expected behavior. And that's why that was written in too, by the way. It didn't used to be. It used to be just code of conduct. And then it was students' rights and code of conduct. But now it's rights and responsibilities, because the law says, all right, you tell students what they're not supposed to do. Now, the law is you have to tell them what they are expected to do rather than what they're doing. Consequences and appropriate remedial action for a person who commits these. It has to be written into your code of conduct now, just like anything else. There has to be a remedial action, some kind of a bullying prevention program. There must be a procedure for reporting that bullying, harassment. You'll notice in Charlotte-Mecklenburg, in your Rights and Responsibilities Handbook, there is a form in the actual handbook that students can use to report bullying. You can write it down and do it anonymously. Procedure for prompt investigation. That's why I said the principal or principal designee is the person responsible for starting the investigation. And that principal's designee may be somebody, as I said, from the central office that comes out and does this. Or it may be an assistant principal, but there is a procedure. That's why you call and make sure this is what happened. What do you want me to do? A statement that prohibits reprisal or retaliation. And see, that's part of the investigation too, is you need to set your investigation up so the likelihood of reprisal will be lessened. And a statement of how the policy is to be disseminated and publicized. We put it in the Rights and Responsibilities Handbook, which is online. I don't think they're still giving out hard copies. Luke, I don't believe that's happened, but it's online. And it's on the website, and it's disseminated. We used to actually put a hard copy in every kid's hand to take home. Not only did we have it on the website where it could be accessed online, we used to actually physically put it in every kid's hand. Okay.
It doesn't happen no more.
Cost is very expensive. Nothing in this article shall prohibit a local school from adopting a policy that includes components beyond the minimum components. That's why I said you need to call. Your district may have additional requirements other than the ones I just went over. And again, just like Lou's talking about, we don't generally publish these things anymore. They're online somewhere. You may not know exactly where it is. It may not be at your fingertips. Notice local policy shall appear in any school unit publication that sets forth, and that means it's got to be on the website. When this first came out, it was interpreted to believe that there had to be a publication, but I think they've gotten around that now because of the cost. But we used to actually print it and stick it in every kid's hand. And it has to be incorporated in the employee training program. And by 2010, every unit had to provide training, not only for employees but volunteers and vendors. That's why I said that vendor reported it, because he'd been through the training, because he was required as part of being a vendor in CMS, the training by that time, and for vendors, and it happened around that time. I'm sure he'd probably just by complete coincidence, he'd probably recently gone through that training. Because anybody who has significant contact with students, who comes and works on schools every day, that's what people do that work on scoreboards, they work at schools every day, they had to be trained in this stuff, and I'm sure that's why he reported it. Mm-hmm. What is sexual harassment? It is sexual in nature, it's unwelcome, and it denies or limits a student's ability to participate and benefit from the school's education program. It can take different forms. It can be carried out by school employees, other students, and third-party people like a visitor or a vendor. Both male and female students can be victims. The harasser can be same-sex or opposite sex. Making sexual propositions or pressuring students for sexual favors, touching of a sexual nature. Now, again, touching goes over the line. Touching goes over to sexual assault. Graffiti of a sexual displaying drawings, written materials, performing sexual gestures or touching oneself in front of others, telling dirty jokes, spreading sexual rumors, rating other students. This is what happens a lot online with Instagram and Twitter. That's cyberbullying, but it's the same thing. Circulating, showing emails or websites, sexting, passing along pictures by the phone of naked yourself or others. And so sexting is not illegal, but it is prohibited. And especially if the girls are underage. The big case in Charlotte-Mecklenburg was a boy at Huff High School who was 18, and he was sending out pictures of underage girls that he had taken, or they had enticed him to send to him, or he somehow had gotten them inappropriately. But now that is against the law because they were underage. Sexting is not illegal between two consenting adults, but includes participant who is under 18, then child pornography laws doing so. So it is illegal for students to do that. See that's one of those things that I hear all the time when parents will complain. Well, sexting's not illegal when you go to punish it. Well, it is if you're under 18. Either sending or receiving. If you're under 18, it is because it's child pornography. Mm-hmm. So, to consenting adults, sexting is not illegal. It's in bad taste, but it's not illegal. But for students, it is illegal. And it's illegal if a 15-year-old girl takes a picture of herself and texts it to somebody else, that's against the law. She has committed a violation. And this goes on to talk about sexting, and then has some cases in here about is a hug sexual harassment. It is if it's excessive and unwanted, and there's other touching that goes along with it, but it won't always be, but it can be. A high school athletic coach hugs a student who makes a goal. This by itself is not sexual misconduct. But if it's unwelcome and occurs under inappropriate circumstances, like they're in his office alone, yeah, that would be sexual misconduct and would be a sexual assault. Criminal versus non-criminal, and that's what I was trying to talk to you about earlier. Sexual harassment includes conduct that is criminal in nature. This slide's a little misleading, but what it means is sexual harassment's against the law. But you can be guided in your investigation of it. These others are against the law, but they are acts of crime and violence, and the police need to lead the investigation in those. The point of it that both of these are against the law is that there is an investigation required. That's the notion here. The debate is if it's criminal. If it's an act of crime and violence, the police need to do the investigation. If it's just a violation of the law, but it's not criminal in nature, if it's harassment, then the school can lead the investigation under the direction of the people in the central office, the Title IX coordinator or the disciplinary data coordinator. And this just reinforces my first argument tonight again is you need to know the difference. You need to know the definitions. If what they tell you falls under the act of crime and violence, then you need to get the police. Must the conduct be unwelcome? Yes. The age of the student, the nature of the contact, the mental state of the child, all those things have to be factored in. And then there are some examples here, and I won't go through all of these. This could take the rest of the night. But remember, harassing behavior, if not, becomes worse. There are some antecedents to sexual harassment, obscene gestures, screaming profanities down the hall, inappropriate displays of affection. Those are all antecedents that you've got to deal with. Otherwise, it will become sexual harassment. If you don't deal with that, it becomes worse. The impact of sexual harassment on a student's educational progress and attainment of future goals can be significant and should not be underestimated. Students may, for example, have trouble learning, drop a class, or drop out of school altogether, lose trust in school officials, become isolated, fear for personal safety, or lose self-esteem. These are all things that can happen as a result. So you must take this seriously. You must know the legal process, whether you're to conduct the investigation under the direction of the folks from the central office or whether the police are to conduct the investigation. And again, it goes back to the definition. If there's any physical contact involved, we go to the police. All right. Questions, Luke, Julietta, any questions about this tonight? I know this is a kind of long and boring one, but well, I tell you, this one costs more people their jobs than anyone else that I know of right now. Getting this one wrong. This one ends careers quickly. There's no rebound from this one. There's no go sit in time out for a while. You'll be okay on this one. This one is you have to pack your stuff and go home. And that's why I felt like it required an entire session to go over this one. All right, got one more to go, one more hill to climb. I'll talk about interviewing next week because I may not have you again. I may get you again 6:05. I hope I do, but if I don't, I want to make sure that we go over interviewing because you're going to be interviewing, and you didn't go through all this process of having to sit and listen to people like me drone on all this time without the idea of getting a job in the end. The interview process can be a minefield to get through. Hopefully I'll have some things for you next week that'll help you get through that minefield and get through those interviews and get you a job. So if there are no questions, I've run past my time about 5 minutes, and I apologize for that, but I will see you all again next Wednesday. Y'all have a good week.
You too. Good night.
Good night.